Distinguished panelists, guests, colleagues, ladies and gentlemen, welcome to the 12th ASEAN-Australia Counter-Trafficking webinar series on adaptive justice responses on trafficking in persons under the new normal. Thank you for dialing in for our webinar today from different parts of the globe. So exciting to see that more than 400 have registered in this webinar. This webinar will present different alternative modes of hearing trafficking in persons cases, featuring distinguished international and regional speakers who will be introduced later. I am Darlene Pajarito, the Justice Systems Director of ASEAN-ACT, dialing in from Bangkok, and I will be moderating this webinar. Co-moderating with me is Mr. Kem Siguan, our ASEAN Program Director. To guide us on the house rules, let us listen to this video.
Hello, thank you for joining us today. We would like to make this virtual event a pleasing and productive experience. To make this happen, the organizers request all participants to observe the following house rules. You may use the chat box when you want to provide inputs or comments. For documentation purposes, this event will be recorded. If you require special assistance to take part in this event, please notify our event organizers so that we can accommodate to your needs. Please click on the interpretation button at the bottom of your screen to select the language of your choice. Our interpreters are on standby. Lastly, as we are in a virtual environment, we will be kind to one another in case of internet connection issues. We will expect unavoidable technical difficulties. Feel free to join back if you're disconnected. Everyone's patience will be greatly appreciated. Thank you for your attention.
Thank you very much, Eve. So except for Vietnam Intermediate Judge Ta Sui Hua, all the speakers will be speaking in English. Please click on the desired interpretation channel to listen to our speakers. We only have 5 customized channels for English, Cambodia, Bahasa Indonesia, Myanmar, Thai, and Vietnamese. So if you want to listen in Lao, please click on the Spanish channel for translation. Also posting here in the chat box is the link of the ASEAN-ACT portal where the Zoom recording of this webinar, including the PowerPoint presentations and materials, will be made available. To formally open the webinar and deliver his keynote remarks, we are very honored to have with us Australian Ambassador to ASEAN, His Excellency Will Nan-Curvis. I am highly delighted to pass the virtual floor to you, Ambassador.
Well, thanks very much, Darlene, and good afternoon, counter-trafficking partners, practitioners, advocates, and colleagues from around the ASEAN region and beyond. It's really great to be here with you today, and welcome to the second ASEAN-Australia Counter-Trafficking Program webinar for this year, part of a series which explores adaptive justice responses to trafficking in persons. This year's theme, this month, of course, will mark, as all of you will know, will mark World Day Against Trafficking in Persons, which is observed annually on the 30th of July. This year's theme, the use and abuse of technology, focuses on the role of technology as an enabler of trafficking in persons, particularly during the COVID-19 pandemic. Human trafficking is a lucrative industry which preys on the most vulnerable in our societies. Unfortunately, technology has made trafficking even more profitable by enabling criminals to diversify their modus operandi and target a wider range of groups. Social media and other online platforms are a fertile breeding ground for traffickers to entice, deceive, and coerce victims into sexual or labor exploitation. While swift and informal online payment systems make it easier for traffickers to transact their deals. As a result, we've seen an increase in online exploitation, particularly of children, and a concerning trend of scamming and deceptive recruitment leading to exploitation, in some cases of citizens from ASEAN countries being held captive for ransom. However, it's not all doom and gloom. As this year's theme for World Day Against Trafficking suggests, technology is also a powerful tool to prevent, disrupt, and respond to human trafficking. While traffickers have been capitalizing on the opportunities to abuse technology, the counter-trafficking sector has also evolved and embraced the use of technology in the fight against trafficking. Today's webinar will illustrate how technology-based solutions are being used to pursue better justice outcomes in trafficking cases, while also protecting the rights of victims and other witnesses in criminal trials. On our panel today, we're honoured to welcome His Honour Judge Martin Picton, International Training Director at the Judiciary of England and Wales, Judicial College of Bristol, Crown Court, the Law Courts, United Kingdom. Presiding Judge Cristina Jabalera Sulit from the Regional Trial Court, Branch 140 in the Philippines. Intermediate Judge Ta Sui Wa, Deputy Chief Justice of the Criminal Court of Quang Ninh Province in Vietnam. And Attorney Kathleen Joy Piccho Labai, Head of Prosecution Department, International Justice Mission, Philippines. Our distinguished speakers will be asked to consider the question, can alternative modes of presenting victim testimonies increase the chances of conviction? It's widely accepted that victim testimonies are heavily relied upon in securing a conviction in a trafficking case. In the ASEAN region, many trafficking cases don't proceed if there's no victim testimony. While the use of circumstantial and corroborative evidence in trafficking cases is increasing, this evidence is often not sufficient to support a conviction. Given the centrality of victim testimony in trafficking cases, it's important to have judicial and administrative processes that are responsive and sensitive to the needs of victims. This is explicitly acknowledged in the ASEAN Convention Against Trafficking in Persons, especially women and children. There are examples from across the region of member states that are adopting alternative modes of evidence presentation that protect the victim's safety and privacy without affecting the rights of the defendant. Today, we'll hear about some of those innovations from within the ASEAN region. We'll also be looking beyond the region to listen and learn from other jurisdictions. We're privileged today to have three esteemed judges who will discuss the use of alternative modes of hearing victim testimonies in trafficking cases. It will also be exciting to hear directly from Attorney Piccho Labai, who was involved in a very recent trafficking case, where the victim was able to provide evidence from her home country, the Philippines, during using video conference at the French embassy, the embassy of the country in which the matter was being heard. I trust that this webinar will generate important lessons for us all, especially for counter-trafficking actors focused on improving responses to trafficking and protecting the human rights of victims. On behalf of the Australian government, thank you for your strong interest and participation. I apologise again for the technical difficulties that left you all hanging for a while, but glad the connection was finally remade, and I really wish you all the best and a very successful webinar. Thank you.
Thank you so much, Ambassador Wilnan Kervis, for the inspiring message. It is indeed very timely for this webinar to talk about using technology to work in our favor and one that can best protect the victims of trafficking. Of course, and in line with the theme of the World Day Against Trafficking, which is the use and abuse of technology. And we're just as excited to listen to the lessons learned and the experiences of our panelists. Now that the tone of the webinar is set, we can't miss this very important part, the group photo, of course. So everyone, please kindly put your camera on. On cue, our Bangkok Excellent Support Team will take the screenshot. Two shots, one, the second one with the wave. All right, hope everyone's ready. All right. Now, can we have another shot with the wave, please? All right, great. Thank you so much. There you go. Thank you, everyone. Thank you, Eve. So if you recall, we have our, as I mentioned earlier, we will now see the feedback slide from the last webinar. All right, there you go. So from our previous webinar, 91% of our online audience said that the topic was very relevant to their work, while 92% said that they learned something new and that the speakers were knowledgeable. And 84% believe that the webinar was very useful. We also received a very interesting feedback, and I quote, "The online platforms shared during the session can be very helpful in keeping track of the statistics and comparing them from the local data that we collect. From there, we can draw conclusions and maybe create strategies in encouraging more local government units to be dedicated in keeping a record of cases of trafficking in persons and sharing them to us at the national level." So a very relevant recommendation that reflects a very good understanding of the value of having the right data that is accessible. Thank you to the participants who've shared this feedback. This is very well noted. And as always, we love your feedback and value your comments and suggestions so that we may better serve you. Please indulge us again and complete the feedback survey for this webinar. The link is in the chat box. We will also send you a certificate of attendance upon the completion of the survey. All right, so just a brief overview for today's webinar. We will have the opportunity to listen from the experts to discuss about specific modes of presenting the testimony of witness using victim-sensitive, trauma-informed, and gender-responsive approaches. Our esteemed panelists will share their experiences in using these alternative modes of evidence presentation before the courts. So there you go. We have our panelists. As excited as we are to listen to the presentation, allow me to take a few minutes of your time to answer two poll questions first. The results generated from the polls will be solely used for this webinar. No identification is needed for you to answer these poll questions. We will now display the poll questions on the screen. It won't take long, just two questions. All you have to do is just click on your choice. There you go, the question. For purposes of translation, I will read the poll questions. Question number 1, given the continuous advancement of technology, how do you foresee the future use of alternative modes of presenting evidence in your jurisdiction on TIP cases? First bullet, gradually increasing. Second bullet, only in specific cases. And third bullet, not likely to happen. Click on your choice and we'll move on to the second question. In your knowledge or experience, what do you think is the most challenging in using video conferencing as an alternative mode of presenting evidence? First bullet, lack of enabling legal frameworks. Second bullet, weak or unstable internet connection. And third bullet, inadequate knowledge. And the last bullet, lack of suitable equipment such as camera, recorder, or screen. Again, please click on your preferred answer from among the choices. We will present the poll results after the presentation and reflections from our esteemed panelists. All right, so these poll questions will remain there for a while, but we will proceed to our main presenter. Let me introduce His Honor Judge Martin Picton. Judge Picton was called to the bar in 1981 and practiced as a barrister in private practice from then until being appointed as a circuit judge in 2005. He was appointed a recorder at that time on a part-time, and in 1998, authorized to try both criminal and civil cases. Judge Picton has been a tutor judge for the Judicial College since 2004. He was the course director of the Judicial College Serious Sexual Offenses Seminar from 2011 to 2017. He was the course director of the Judicial College Vulnerable Witnesses Seminar in 2014 and 2015. Judge Picton was a member of the Criminal Procedure Rule Committee from 2012 to 2021. He is the lead editor of the Crown Court Compendium since 2017. He has been authorized to sit in the Court of Appeal Criminal Division since 2016 and was appointed a Deputy High Court Judge in 2018. In 2021, Judge Picton was authorized to sit in an administrative court, and in that same year, he was appointed and is currently serving as the Director of the International Training for the Judicial College, Bristol Crown Court in London, UK. Please welcome Judge Martin Picton.
Good morning. Sorry, just get my get the mic on. I'm very happy to speak to you all today from Bristol, which, if any of you know it, is in the West Country of England. And I'm going to run through some slides which will take us through this presentation dealing with vulnerable witnesses and pre-trial cross-examination. I'm going to review some of the measures that we adopt in England and Wales that are designed to assist vulnerable witnesses to participate in the criminal justice process, but in particular focus on pre-trial cross-examination, which is a relatively new innovation in its use in England and Wales, but which is designed to enhance some of the other special measures that we've been using for rather longer. I'll start by outlining in a few sentences the principles that we currently apply. The court here is required to take every reasonable step to encourage and facilitate the attendance of witnesses and to facilitate the participation of any person, including the accused, in the criminal process. And this includes enabling a witness or accused to give their best evidence and enabling an accused to comprehend the proceedings. The pre-trial and trial process should, so far as necessary, be adapted to meet those ends. Vulnerability as a concept may arise by reason of age, but also encompasses anyone who may not be able to participate effectively if reasonable steps are not taken to adapt the court process to their specific needs. A ground rules hearing, which I'll say more about later, held in advance of the witness being called to give evidence, is an important element of trial preparation where there are vulnerabilities of which account needs to be taken. A judge must stop over-rigorous and repetitive cross-examination of a child or vulnerable witness or a defendant. Intervention by the judge is minimized if questioning, taking into account the individual's vulnerability, is discussed in advance and ground rules are agreed and adhered to. Where appropriate and available, an intermediary can be a valuable tool to facilitating communication, but even in the absence of such professional input, our experience is that there is much that a judge can do by way of adaptation of the trial process to meet the needs of the witness. This first slide refers to what we call the Pigott report, dating back as long ago as 1988, an inquiry carried out by a senior judge to look at the process by which the evidence of children was used in our courts. The proposal was that children should be taken out of the courtroom as witnesses effectively by way of them giving evidence remotely and pre-recording cross-examination. Next slide, please. It took a while for the recommendations of that report to filter through the system to begin to make changes. But in 1998, a Home Office report speaking up for justice recommended that there should be what we term special measures introduced that enable vulnerable or intimidated witnesses in a criminal trial to give their best evidence. Next slide, please. That promoted the legislation or a legislative change in the form of the Youth Justice and Criminal Evidence Act 1999, introduced with a view to facilitating the ability of vulnerable and or intimidated witnesses give evidence efficiently and safely in criminal court proceedings, and provided for a range of special measures designed to assist in that process, essentially focusing on reducing the level of stress and pressure that witnesses feel when giving evidence at court, which is significant and can be a significant barrier to the trial being decided upon evidence and not just on whether the witness can cope with the process or not. Next slide, please. So what are the special measures, as we term it in England and Wales? The Act sets out, by way of statutory permissions, designating certain special measures that the court can adopt in order to make the trial process available and effective for vulnerable witnesses as participants in it. And so Section 23 of the Act makes specific allowance for the use of screens. And by screens, I'm talking about just a physical barrier, a curtain on a frame that will be a barrier between the witness and the accused person and also people in the public gallery. So the witness doesn't have to look at the person that they accuse of committing the offence against them when they're giving evidence, that they have a degree of physical protection from that person. And that avoids potential physical intimidation simply by seeing them. Section 24 allows for the use of a live link, and that allows a witness to be in a remote location but give evidence to the court with them appearing on a screen in the courtroom so they can be seen and be heard. I have earlier in this year completed a 3-month trial involving allegations of human trafficking, in which the vast majority of the witnesses had returned to Slovakia from where they had come originally and been forced to work for no payment in the United Kingdom. And they gave their evidence from Slovakia, and that evidence was heard by the jury here and tested over the live link in cross-examination. Section 25 allows for evidence in private. If it is too intimidating for a witness to even be aware of people in the courtroom watching them when they give evidence, you can, in an appropriate case, clear the courtroom. Section 26 may not be entirely relevant to all of you. Removal of wigs and gowns. We're still really committed to dressing up in court in England and Wales, so we like to wear horsehair on our heads and fancy gowns. You probably don't. We still do, but we're allowed by statute to take them off in an appropriate situation. Next slide, please. Section 27, video recorded evidence in chief, a really important tool in the process of gathering and presenting evidence from vulnerable witnesses. The police will interview the witness by way of effectively taking a witness statement, but that process will be video recorded, and that video recorded account will be presented at trial as the witnesses, as we term it, evidence in chief, what they say on behalf of the prosecution in support of the charges. And so they don't have to repeat and keep repeating the account of the criminality to which they say they were subject. And that video recorded evidence in chief is served in advance and will be edited. In my system, we use juries, and so an edited version of that account will be presented to the jury with only the relevant parts kept in. But the same can apply even in a non-jury process. Section 28, which I will come to later, is the second stage of the video recorded evidence in chief. It was what His Honour Judge Pigott back in 1988 recommended, that at an early stage in the proceedings, and rather than waiting until months or sometimes years down the line when the trial actually takes place, a child or otherwise vulnerable witness is cross-examined in advance, and that cross-examination is recorded and is then the evidence later considered in my system by a jury, in other systems by a judge or judge and assessors, whatever the constitution of the court may be. But you capture the first account early by the police, and you capture the cross-examination again much earlier, before lots of the work on the case has been done, so that it allows for the witness to move on in their life, allows for a child to be cross-examined when they may have a better memory of what happened. Section 29, intermediaries, professionals who can assist with communication. We use those here in an appropriate case. I see someone put a message up saying no sound. I'm hoping that people have got sound from me, but it may be someone's got an issue. And section 30 refers to other aids to communication. I'm aware of a case where a witness was so disabled they could only move their fingers and were able to answer questions by use of a keyboard, effectively keying yes and no in response to the questions. Next slide, please. In terms of eligibility, and I won't spend very long on this because you've got the slides available to you, but essentially eligibility for special measures focuses on age, focuses on whether there is a mental disorder or learning disability, physical issues, focuses on the effect of the process of giving evidence on the witness because of their circumstances or those relating to the case. The court is always required to take account of the views expressed by a witness. So where a witness has the capacity and maturity to express a view, we of course take full account of that and don't drive the process against the witness's wishes. Next slide, please. And so our position at the moment is that complainants, for example, in respect to sexual offences, are automatically eligible for special measures, whatever their age. And offences under our legislation in relation to human trafficking, our Modern Slavery Act 2015, are automatically eligible for the special measures of the kind that I have mentioned. And it also encompasses victims of domestic abuse. And as the second bullet point refers, there are others who may be eligible for special measures, although not directly the complainant, but others affected by particularly heinous crimes that we recognise as having a traumatic effect on those who are touched by them. Next slide, please. We have a specific provision dealing with witnesses subject to fear or distress, and that will encompass many who have been the subject of human trafficking. And the court is looking at the quality of the evidence that might be given by the witness and whether it is to be diminished or likely to be diminished by reason of fear or distress, related to the circumstances of the offence, related to the age of the witness, and related to other matters that I cover in the next slide, please. The court looks at a broad range of factors that may be relevant to this assessment: social and cultural background, ethnic origins, domestic and employment circumstances, religious or political beliefs, and behaviour towards the witness on the part of those accused of crime, members of the family or associates of the accused, or any other person who is likely to be accused or who is likely to be a witness in the case. So the court can take a very broad view of the circumstances of the case in terms of deciding whether special measures are engaged and which should be used. Next slide, please. And again, repeating some of the points, but explaining again the wide range of issues that are covered. And we can go on to the next slide because I've covered most of those already. And again, the court looking at behaviour towards the witness on the part of the accused, members of the family, associates. Again, focusing on how the witness may be impacted upon by the overall circumstances of the case and everything attaching to it. Next slide, please. Again, some legislation references there that you can look at your leisure if you find it helpful. But here, the court, once it's decided a witness is eligible, must look at what factors, what measures are appropriate to adopt in those circumstances, but also bearing in mind the need for the accused to be able to effectively challenge the evidence. And so it looks at which measures should be adopted or a combination of them. Next slide, please. And gives a direction under the legislation as to which should be used. So to summarize, the court looks at the witness. It looks at the nature of the offence. It looks at the surrounding circumstances. The court considers what may help, and having considered those matters, considered the capacity to effectively challenge the evidence, the court orders such measures to be adopted at trial as is appropriate in the particular circumstances of that case and that witness. It is not a one-size-fits-all process. The special measures, directions, and the adaptations of the court process are those that are necessary in that particular case or on all the circumstances that pertain to it. Next slide, please. And as I've mentioned, little a and little b there, the view, any views expressed by the witness, obviously with a child witness, their views may not be of the most significant weight, but with an adult witness, it may be very important, and whether the measure or measures might tend to inhibit such evidence being effectively tested by a party to the proceedings. The legislation is very much designed to facilitate the receipt of the evidence, but also to ensure that that evidence is capable of being challenged. Next slide, please. And as you might imagine, the primary rule in the case of a child witness is that the court must give a special measures direction in relation to the witness, which complies with the requirements I've there set out. It must provide for any relevant recording to be admitted under Section 27, video recorded evidence in chief. And it must provide for the evidence given by the witness, which is not given by means of a video recording, to be given by means of a live link in accordance with Section 24. So it has been a very, very long time now since I have seen a child give evidence physically present in a courtroom with the judge, with the jury, with the defendant. Decades since I've seen that happen. Children have effectively been at least physically removed from the criminal trial process. Next slide, please. Pre-recorded cross-examination. I have to say it's taken quite a long time to reach the stage of implementation here, given that it was first recommended in 1988. We started with a pilot process. I think it may actually have been as late as 2015. There might be a typo in the slide there, but we set up some pilot courts where by a legislative change, courts were permitted to start adopting a process of pre-recorded cross-examination. Initially for young and vulnerable witnesses, that then was subject to a national rollout, which is now complete. So in England and Wales, every court will receive the evidence of young and vulnerable witnesses where appropriate by way of video recorded evidence in chief, and if the court orders it, as it often will, pre-recorded cross-examination. And there is a phased rollout currently underway that also accommodates vulnerable witnesses within this process. And so this includes complainants in cases of alleged sexual offences, domestic abuse, and people subject to human trafficking. And Section 28, pre-recorded cross-examination, is the right option if it will improve and maximise the quality of the evidence. And in any case where that is going to happen, where there's going to be Section 28 pre-recorded cross-examination, it is almost inevitable that there will be a ground rules hearing to address how that process will be conducted in advance, certainly in any case where there is a child witness. Next slide, please. In order for pre-recorded cross-examination, you have to begin with the police having taken a video recorded account from the witness. In the sort of cases that I've mentioned, that is almost universal. It is important that the court identifies the eligibility of a witness at an early stage. And it's important that the court immediately adapts the case management processes to accommodate that is what's going to happen, because evidence needs to be served more quickly than is the case in other cases, and pre-trial disclosure needs to be accelerated so that there can be effective cross-examination of the witness at a much earlier stage than is normally the case. And the court will, at an early stage, consider the need for a ground rules hearing. The court will list the case, setting dates for the Section 28 pre-trial cross-examination, and then a later date set for the actual trial, which of course will take much longer. So it's easier to fit in a relatively short cross-examination as part of a normal sitting day, and then to set aside further time for the trial itself at a later date. But the Section 28 pre-recorded cross-examination is the start of the trial. It is the first day of the trial, even though in our system, there is no jury present when that happens. Next slide, please. Part of the process of getting a case ready for the pre-recorded cross-examination is that judges, particularly in a child case, will require the advocates to look at what we call the Advocates Gateway toolkits. They are available to the public. They provide really helpful guidance on how you go about cross-examining a child or otherwise vulnerable witness. And they have the approval of the senior courts in England and Wales, and judges will regularly say to an advocate, your cross-examination of this vulnerable witness must be compliant with the guidance there available. And we have a process increasingly now where the advocate is required to write out the questions that are to be asked in advance, and for that cross-examination to be subject to judicial editorial control. And that means that when the pre-trial cross-examination takes place, the advocate works through the questions and the judge records the answers. The process is stored and held. We've got a provider, Vodafone, who you probably heard of. They store all these recordings that are then available to be played at the eventual trial. It means that it doesn't have to be the same judge who deals with the pre-trial cross-examination that in fact ends up conducting the trial itself, although one can see there may be some desirability in that. There is a potential after the pre-trial cross-examination for the recording to be edited if something's been said which is not admissible at trial. And there is the potential for further questioning of the witness later if it turns out something wasn't asked that needs to be asked. But that is very, very rare. I have not known any case that I've conducted where there's been any further cross-examination. I know of very few instances where that has happened. The witness is essentially out of the process once a pre-recorded cross-examination has been done. Next slide, please. Ground rules hearing, I've mentioned that. It's a really useful tool in ensuring that the cross-examination is dealt with appropriately and that it addresses the right issues. So the greater the level of vulnerability of witness, the more important it is to have such a hearing. Next slide, please. Adjusting for vulnerability. I just want to check how much longer I've got. I think I've got 25 minutes. So if I'm coming up to a 5-minute warning, can someone let me know how much longer have I got, Darlene?
5 more minutes, Judge.
I had a feeling I might be getting there. There's a lot more slides to go. Never mind. I will finish these last ones. Thank you. So adjusting for vulnerability. Just some pointers that we have come to use more and more in vulnerable witness cases. Making decisions as to when the witness will be called, whether at trial or by way of pre-recorded cross-examination. Children always do better in the morning. I will never have a child witness called in the afternoon. They will be called as a part of the school day when they are most awake and most able to engage. Meeting witnesses in advance is a really useful part of the preparation for them to give evidence. Taking breaks where needed. Intermediaries, I don't know whether you have experience of those. We use intermediaries quite a lot with witnesses who have communication issues, and they can be very helpful in relation to ensuring the witness can communicate. And a couple of cases there that are touchstones of procedure in the courts here. The case of Dink, requiring the advocate to submit questions in advance, and the case of Lubemba, duty to control the questioning of witnesses, set reasonable time limits, and to interrupt where there's inappropriate questioning. They are essentially sanctioning the judge taking control of the process and not permitting the advocate to do simply what they want. Next slide, please. This exercise of editorial control is designed to ensure that the questions put to a witness are actually questions and not simply comments. And I've set out there how you go about that, and you can reflect upon that if you think it's helpful later. Don't have more than one advocate questioning a witness about the same issue, and adapt the processes to ensure the questioning is fair. The final slides, if we could just move on to the next one, and I haven't got time to go through all these, but the purpose of the final slides is to address the other side of the coin, as it were. A lot of defendants who end up in our courts themselves have significant vulnerabilities, and it is, in our view, as important for defendants to be able to effectively engage with the process as it is for the witness. They have to, and we have to adapt the proceedings, the way we conduct the proceedings, to assist them. So we may have defendants with intermediaries. I may require a prosecutor to write out the questions in advance for a vulnerable defendant. So the remaining slides, and I won't take you through them, but they simply set out the way in which we have developed our learning here as to how you must make sure that both sides are covered in terms of vulnerability. And I think probably that is me timed out, and you can go if you want to the final slide just to get the end, but that is the end of certainly what I've got time to say, but you're very welcome to look at the later slides and take from that anything you find helpful. So that, I'm afraid, is a bit of a rush through the way in which we have developed pre-trial cross-examination. I hope it's of some interest to you. Thank you.
Thank you so much, Judge. That was really very informative, very comprehensive. It's a pity that we don't have enough time, but we're sure you'll have enough time later on during discussion. This is really something new for most of us in the region. Look at your country's good practice on modes of receiving or presenting evidence and how it is being appreciated by the courts, especially where cross-examination evidence is received in advance. But of course, I'm glad that you mentioned there's still a balance between the rights of the victims and the rights of the defendants in any case. So now that we have a panel of experts who would like to give their response or reflection to your excellent presentation. Let me first introduce our esteemed panelists. We have presiding judge, Christina Havalera Sulit. She has a lustrous career as a lawyer and as a judge, being a recipient of various awards. She is recognized as an outstanding member of the Integrated Bar of the Philippines. She was awarded the Prosecutor of the Year in 2000, natatanging anak ng Lopez Award by the local government in Lopez, Quezon, a sought-after resource speaker on cases involving children and family matters. Judge Sulit was invited to speak in Bangkok way back in 2017 on judicial challenges on online sexual exploitation of children cases. She was also invited by the International Organization for Migration in 2018 to speak to judges and prosecutors of the People's Republic of China in their seminar on trial of trafficking cases held in Beijing. Currently, she's the presiding judge of the Regional Trial Court Branch 140 in Makati, Philippines. And as a family court judge, she has served in several committees and technical working groups that involves the family courts and juvenile concerns, and including the drafting of the implementing rules and regulations on the social impact of the Family Courts Act of 1997, and the Supreme Court Bench Book for Family Cases. Our second panelist is no less than the distinguished intermediate Vietnamese judge, Ta Suy Hoa. He is the Deputy Chief Justice of Criminal Court of Quang Ninh Province in Vietnam. He is a Bachelor of Law graduate at the Hanoi Law University and took advanced training on adjudication at the Justice Academy. He completed his Masters of Law at the Ho Chi Minh National Academy of Politics. Judge Ta Suy Hoa also worked in court since 2009 and was promoted to be a judge in 2010. He became an intermediate judge in 2018 and has a lot of experience in adjudication of criminal cases, including TIP cases. Our last, but certainly not the least esteemed speaker, Attorney Kathleen Joy Picshaw Labay. She joined the International Justice Mission in 2013 and currently serves as the head of prosecution development for the IJM Manila Program Office. She is actively prosecuting cases of online sexual exploitation of children, or ASEAN-ACT, human trafficking and child abuse cases, and collaborates with public prosecutors, law enforcement authorities, local and foreign, both local and foreign. Also works with social workers, shelter partners, and civil society organizations in securing justice for victim survivors. She obtained the fastest OSEC conviction in 2018, just 4.5 months. And in 2020, she obtained the IJM Philippines first OSEC conviction of a foreign national through an online promulgation of judgment, which was received very well in the international arena. The Supreme Court even publicly mentioned this case on May 31, 2020, citing the initial success of video conferencing hearings nationwide. She's also one of the authors of a compendium of legal resources for the prosecution of online exploitation of children, which is now being used by government prosecutors. So Judge Chris Sulit, Judge Ta Sui Hwa, and Attorney Kathleen, given your vast experience on prosecution and adjudication of TIP cases, may we hear your insights and reflections on what was just presented by our Judge Picton? Anyone can take the floor, please.
Okay, can I take the floor first?
Yes, please, Judge.
Thank you. Good afternoon or good morning to everyone. Judge Picton, we are delighted to tell you that we learned a lot from your presentation. Thank you. We find similarities in those measures which we are applying in the Philippines. We have our Rule on Examination of Child Witness under AM number 004-07 of the Supreme Court. In this rule, the Philippines is giving proactive approach in handling children who are appearing in our courtroom, regardless of whether they are victims, witnesses, or they are offenders. But before explaining the similarities of our procedures, let me point out our differences, particularly in the eligibility requirements. Okay? Number one, in your jurisdiction, it appears that the procedures are applied only in cases of sexual offenses, offenses under the Modern Slavery Act, domestic abuse cases, and human trafficking cases. In the Philippines, our child witness rule applies to all kinds of cases: murder, kidnapping, abduction, trafficking, human trafficking, illegal possession of drugs, among others. Okay, number two, in your jurisdiction, even adult witnesses can avail of these special measures. But in the Philippines, only the child victim or child witnesses to a crime can avail of the special measure even without any disability, meaning to say the child is a normal person, not suffering from any mental disorder. Okay. Number three, in your jurisdiction, only the child victim and the witnesses are eligible to avail of those special measures. In the Philippines, even the offender could avail as long as they are below 18 years of age, whom we call children in conflict with the law, or CICL. Thus, regardless of whether the child is a victim or a CICL, the same rule on examination of child witness shall apply. Okay. Some of the alternative modes of presenting the child in our rules are, okay, number one, videotape deposition in criminal cases if the child is sick, infirm to attend the trial, or has to leave the country with no definite date of returning. The deposition of the child victim should take place at the very same court where the case is pending, not necessarily in the courtroom. It could be in a witness room, or in child rooms, or in the chamber of the judge, okay, to give a comfortable environment for the child. The prosecutor conducts the examination while the judge presides over the session to observe the demeanor of the witness, assess, evaluate the witness credibility. Notice is to be given to the accused and defense counsel to attend the deposition hearing to satisfy the constitutional rights of the accused to counsel and to confront and cross-examine the witness. Okay? Failure of the accused and the defense counsel to attend the deposition is considered a waiver. The videotape deposition shall be preserved and stenographically recorded and shall be subject to a protective order. This is similar to Judge Picton's pre-recorded cross-examination presentation. But the only difference is that the videotape recording shall remain under the custody of the court where the judge presided over the deposition and shall be considered by the same judge in deciding the case. Number 2, another mode of presenting evidence is through live link television. Here, the child gives testimony in a room separate from the courtroom and transmitted via live link facility. The judge, the lawyers, and the parties who are in the courtroom see and hear the testimony of the child victim through the live link television. If the court has no facility for live link, the court could provide screens, one-way mirror, or other devices to shield the victim, the child victim, from the accused, especially if she is suffering from trauma. Okay. Another mode is videotape and audio tape in-depth investigative or disclosure interview in child abuse cases if the child victim is not available to testify in court. Meaning to say, the victim is dead, she suffered from mental illness, lack of memory, or will be exposed to severe psychological injury. This is an inquiry before the filing of the case conducted by a duly trained members of multidisciplinary team composed of police, doctors, psychologists, social workers, among others, to determine whether child abuse has been committed. The individual interviewing the child shall be available at trial for examination by any party. Before the videotape or audio tape is offered in evidence, all parties shall be allowed to view or listen to it and shall be furnished a copy of a written transcript of the proceeding. However, a disclosure interview is not sufficient evidence to prove the guilt of the accused. The disclosure interview shall be corroborated by other circumstantial evidence. Okay. Recently, because of the COVID pandemic, our Supreme Court promulgated rule allowing video conferencing hearings available to all, whether child or not. In the video conferencing hearing, the child victim may give testimony remotely here in the Philippines, in the comfort of child's home, or outside the country, using the Microsoft 360 account of the court. If the child witness is on a foreign soil, the taking of the testimony is before the Philippine Embassy or Consulate Office abroad. The judge presides over the hearing here in the Philippines, and the prosecutor, accused, and counsel are also in attendance. You also have the judicial affidavit rule, which is also available to all kinds of witness, whether old or child. In this rule, the child's narration about the case is made through a question and answer form, taken in advance of the actual trial. The same shall constitute the direct examination of the child. The child has to appear in court, identify the judicial affidavit, and thereafter the defense counsel may cross-examine the child. In this way, it limits the exposure of the child victim. It also saves the time and resources of the court, the lawyers, and the litigants. Our Supreme Court issued the rules with a noble intention of reducing the trauma, the pain, and the agony of the frightened child who comes to court and experience anxiety about what was going on inside a strict and restrictive courtroom environment. Thank you.
Thank you very much, Judge. That was very comprehensive as well, sharing the Philippine measures that the Philippines have. So let us now hear from Judge Taswiwa.
Kính thưa các quý vị đại biểu, thẩm phán Việt Nam tôi đánh giá rất cao phần trình bày chia sẻ của thẩm phán cấp cao Martin Wilson. Đặc biệt các biện pháp thay thế không chỉ dành riêng cho đối tượng là trẻ em mà các nhóm đối tượng khác như nạn nhân của tội xâm phạm tình dục, tội nô lệ hiện đại hay những người có thể sợ hãi, lo lắng và có hoàn cảnh của họ hoặc những người liên quan đến vụ án. Đối với Việt Nam, chúng tôi có những quy định xét xử thân thiện đối với nạn nhân là trẻ em trong đó đảm bảo các cái điều kiện trẻ em có thể đưa ra lời khai trong các điều kiện tốt nhất, như các điều kiện lấy lời khai thân thiện hoặc đưa ra lời khai thân thiện tại tòa án. Khi lấy lời khai đối với người dưới 18 tuổi thì cơ quan tiến hành tố tụng có bố trí để người thân và gia đình đại diện của họ cùng tham gia, hoặc đại diện cơ quan tổ chức xã hội tham gia cùng. Người tiến hành tố tụng được phân công với những người có kinh nghiệm về tâm lý trẻ em. Họ cũng có thể cung cấp bản khai trước tòa mà không nhất thiết phải tham gia phiên tòa. Lời khai trực tuyến hoặc sử dụng bản khai đối với trẻ em trong hoạt động lấy lời khai của các cơ quan tố tụng Việt Nam. Họ có thể lấy lời khai bằng việc ghi âm hoặc ghi hình có tiếng. Thì trên thực tế, hoạt động tố tụng của Việt Nam thì vẫn kết hợp giữa lấy lời khai bằng biên bản với hình thức ghi âm, ghi hình có tiếng. Bố trí phiên tòa để cho bị hại là trẻ em, người làm chứng đưa ra lời khai được tốt nhất, thì tòa án có bố trí phòng xét xử thân thiện. Vị trí của bị cáo và nạn nhân có khoảng cách xa nhau để đảm bảo an toàn cho nạn nhân khi tham gia phiên tòa. Thực hiện xét xử kín khi cần thiết nếu nó có ảnh hưởng đến tâm lý của trẻ em. Tổ chức phiên tòa trực tuyến để bị cáo và nạn nhân không trực tiếp tiếp xúc với nhau, hoặc nạn nhân có thể không trực tiếp tiếp xúc với hội đồng xét xử ở một điểm cầu khác. Ngoài ra thì trong trường hợp cần thiết thì tòa án có thể bố trí phòng cách ly để bị hại, người làm chứng trình bày lời khai trước tòa tại phòng cách ly. Trong thời gian gần đây, Việt Nam mới có quy định về xét xử trực tuyến. Một số biện pháp có thể áp dụng trong phiên tòa để giúp hỗ trợ bị hại đưa ra lời khai nhằm bảo vệ nạn nhân và tránh gây sang chấn, tổn hại thêm cho nạn nhân. Tòa án tổ chức các điểm cầu trực tuyến gồm có điểm cầu trung tâm và các điểm cầu thành phần. Trong đó hội đồng xét xử ở điểm cầu trung tâm tại tòa án. Còn đối với các bị cáo thì ở điểm cầu thành phần tại cơ sở giam giữ và họ đang bị giam giữ. Đối bị hại có thể tham gia tại tòa án hoặc điểm cầu thành phần do tòa án bố trí tại các tòa án khác, hoặc địa điểm thành phần mà bị hại hoặc đương sự tự bố trí và có đề nghị bằng văn bản khi được tòa án chấp nhận. Thì phiên tòa xét xử trực tuyến ở Việt Nam được thực hiện bắt đầu cũng chỉ mới gần đây vào ngày 1 tháng 2 năm 2022 theo nghị quyết số 33 của Ủy ban Thường vụ Quốc hội Việt Nam. Hiện nay thì đang được một số tỉnh thành thực hiện. Trên đây là một số kinh nghiệm của Việt Nam xin được chia sẻ với các đại biểu các nước. Chúng tôi cũng rất mong học hỏi thêm được nhiều kinh nghiệm quý báu từ các đồng nghiệp từ các nước. Xin cảm ơn các đại biểu. Tôi xin chia sẻ một số nội dung như vậy. Xin cảm ơn.
Thank you very much, Judge Taswiwa. It was very, very helpful, and we've noticed some similarities on the special measures, and of course, with the same goal to protect victims from intimidating environments. So we will now call on Attorney Kat. Please take the floor.
Good afternoon, everyone. First of all, I'm really amazed that in the UK, children are physically removed from the trial. Video recorded evidence in chief is encouraged, as well as pre-recorded cross-examination. And to me, that seems to be the general rule, that it's preferred and in fact expected and encouraged from the parties. Honorable Judge Picton's presentation is very inspiring and encouraging for frontliners who are combating trafficking and OSEC, or online sexual exploitation of children. In terms of institutionalized child protection measures and child-friendly policies embedded in our criminal justice system, it seems that we're still a mile away, but we are ramping up our efforts to mainstream the use of videotaped in-depth interviews, or what we call VDs, which are video recorded evidence to promote the best interests of children, while at the same time ensuring that we maximize the quality of the evidence and avail other victim-independent evidence. Because upon rescue, we know that child victims are often required to recall experiences of sexual abuse repeatedly in multiple interviews conducted by law enforcers, social workers, and other caseworkers like lawyers. This is very distressing for the children. Eventually, they are also required to narrate these traumatic experiences through live testimonies in open court. We know that court appearances cause anxiety. They fear having to face their abusers and worry that they could be hurt if they meet their abusers in court. They also dread the embarrassment of not being able to answer the questions posed to them. Some fear that they may be thought of as criminally liable and may be imprisoned for it. I witnessed the difficulty that a client of ours experienced in a Philippine court, as well as during the time when she testified before a French court from the French embassy in Makati City, Philippines. Roughly 3 months ago, IJM worked with our strong ally, the Philippine National Police Women and Children Protection Center, French authorities, and the Philippine Department of Justice Office of the Chief State Counsel for this young girl's testimony to be heard and admitted by the French court. We call her Jennifer, not her real name, of course, to protect her identity. What happened in this case was a mutual legal assistance request was sent by France to the Philippine Department of Justice just 3 weeks before the scheduled hearing. The request was granted, and so our dedicated police partners traveled to Aurora province to personally meet with and explain to Jennifer and her mother that there was an optional opportunity for Jennifer to be heard by a French court of law. But before this, we coordinated, of course, first and sought the help of the social workers assigned to manage her case and the psychosocial interventions needed by her. Jennifer and her mother agreed to participate in the criminal proceedings that were taking place abroad. So together with her mother and some female police officers, Jennifer traveled roughly 300 kilometers from her small hometown in Aurora to Makati City, where the French embassy is. It's a 12-hour long drive. The French ambassador welcomed Jennifer and her mom into her own home. So the two stayed at the ambassador's residence safely and comfortably for 3 days. On the day of the hearing, we conducted an online case conference and witness briefing together with a French prosecutor and French lawyer from the NGO called France Victim 37. An interpreter and consular attaché for social affairs were also present. We conducted the briefing an hour before the hearing started. Prior to that, we already prepared Jennifer for trial. We conducted 2 separate witness briefings. I actually asked for guide questions to be sent to me ahead of time so I could prepare Jennifer for the trial and screen questions that have a strong likelihood of causing victim re-traumatization. 14-year-old survivor, Jennifer, who was victimized when she was only 9 years old, testified remotely from the French embassy with a certain kind of boldness and courage that is not normally possessed by many children or even adults. I was not allowed under French rules to sit beside her as a legal representative or support person while she testified. And her mother, who was there, was also not allowed to be present inside the room to prevent any undue influence. We understood that. There was a wall that separated me and Jennifer, but it was a very thin wall. And I could hear the questions that were being asked and everything that Jennifer was saying. Jennifer actually cried a few times, but she always managed to collect herself immediately after and push forward. She was very brave and calm, and she is no doubt already empowered compared to other survivors her age. She wanted to tell the whole story freely. It was really her personal choice, and it was her strong desire to see that justice was served against her French abuser. The only thing that truly bothered her was the fear that her mother might learn the full details of the abuse. She was grateful to receive support from her mother, but also felt ashamed and did not want her mother to know the whole truth and get hurt in the process. But good thing her mother was not really able to hear the whole story. Her testimony lasted for 1 hour. She was cross-examined, but in a very child-friendly manner. The judge asked clarificatory questions, and Jennifer no longer saw her foreign perpetrator. He was not present in the online meeting. The video conferencing hearing made her feel safe, and secure. And this victim survivor is now a young lady, even reminded us stakeholders that the sex tourism prevailing in the Philippines is in fact based on the rape of young children, forced to surrender their bodies for the sexual gratification of adults, obsessed by the search of their own pleasure. That message, those words actually came from Jennifer, and she really made a strong impression on us all. We were all moved deeply by her story and bravery. Thank you. Back to you, Fiscal Darlene.
Thank you so much, Attorney Kat, for that, for sharing us the story of Jennifer. It's really good to listen to the perspective of the judiciary, but also to listen to the story of how the experience of the victim was using all of this technology. So we really appreciate the sharing of Jennifer's story, and also how what the measures that were used to make sure that she is not traumatized in the process. So we're supposed to now go to look at the results of the poll questions, but I'd really like to listen to the response or reaction of Judge Picton, even just very quickly, Judge, to all of the responses from our esteemed panelists.
Thank you. Yes, it's really encouraging how similar our approaches are, and that the thinking behind them is consistent across different countries. And there's much more that it makes us the same than demonstrates a difference. One piece of clarification I should make is that all child witnesses, whether as victims of sexual abuse or just as witnesses generally, are entitled to special measures and get them automatically. So no child, the child doesn't have to be an alleged victim, doesn't have to have any other disability or issue pertaining to them other than age. All child witnesses are eligible for special measures, and therefore no child witness gives evidence in a court, whatever the circumstances. But no, I'm really encouraged by just how similar I thought the experience of the witness giving evidence to a court in France was a good example of how the system works, very similar to what we do, the system we try to operate here, and it's very encouraging.
All right. Thank you so much, Judge. And I'm glad you clarified one point there. So now let us proceed to look at the results of the poll questions. It will be posting this in a minute. And allow me again now to read the results for purposes of translation. So for question number 1, given the continuous advancement of technology, how do you foresee the future use of alternative modes of presenting evidence in your jurisdiction on TIP cases? So we have, for choice number 1, 51% of our audience see that it is gradually increasing, and only 47% said that it will be only in specific cases, and that at least only 3% said that it is not likely to happen. So it seems that our audience are really very positive on this, which is a good thing. And then on question number 2, in your knowledge and experience, what do you think is the most challenging in using video conferencing as an alternative mode of presenting evidence? So we have weak or unstable internet connection as the number 1 challenge at 55%. Then the second challenge would be the lack of suitable equipment like camera, recording, or screen, or others at 22%, followed by the third challenge, which is the lack of enabling legal frameworks, and 7% for inadequate knowledge. So let me call on, for in the interest of time, you will not be able to give your comments to all, to both. So let me just call Judge Martin Picton and Attorney Kathleen Picshaw to give their reaction or response to poll questions number 1.
So perhaps if I go first, just because you mentioned me first. Yes, I agree, gradually increasing. I think it should encompass more cases rather than less, but I think it's a very valuable tool, and we underestimate perhaps sometimes the pressure of giving evidence as a witness generally. So we focus very much on people with particular vulnerabilities, but all witnesses should be treated in a humane and sensible fashion. So far as the challenges, internet connections are always a real difficulty, and having suitable equipment. In my experience, it is depressingly familiar that all the equipment seems to work perfectly before you actually try and use it in the trial. And the moment I have a jury in court with me, it stops working. But that's just anecdotal.
All right. Thank you so much, Judge. Attorney Kat, can you respond to poll question number 1?
I also agree that it's gradually increasing. This is based on our casework experience, where my team and colleagues at IJM are seeing the increase in awareness about the need and value of alternative modes of presenting evidence, especially as a child protective measure. There's also increasing utilization, as in our cases with parallel prosecutions in other countries. And based on this data that we have, the trajectory is definitely upwards in use. Another on-the-ground experience that serves as basis is the presentation of evidence in video conferencing hearings. It's being done and will continue. Perpetuation of testimony before pretrial can also be explored. We've done this in one of our cases in Tarlac province. The prosecutor wanted to consolidate the informations and to prevent delays, since the survivor was present in court that day. The court granted the motion that she be presented. She was cross-examined afterwards. And I would just like to share at this point that the practice of using victim impact statements in lieu of live victim testimony is also an option for parallel prosecutions that are taking place overseas, as it is currently being done by our counterparts in the United States. Thank you.
Yes, thank you. Thank you, Attorney Kat, for sharing that. So let me also invite Judge Chris Sulit and Judge Taswiwa to give their reaction to poll question number 2, please.
Can I speak ahead?
Yes, Judge, please.
Okay. We all agree that the most challenging is the weak or unstable internet connection. Because on my end, I cannot do something about it. I felt helpless. All of us are helpless. As a result, some statements made by the witness were not recorded. The spontaneous testimony of the witness is compromised, or words were not transcribed accurately. Worse, the trial was ended by force for being cut off. It may result in a prolonged trial due to the resetting of the hearing. It is the problem of some, or maybe more, in the Philippines, including myself. Our government needs money, investors, or infrastructure to improve our internet connection. Without them, the slow connection of the internet persists, which may affect the outcome of the case that we are trying. How about the procedure? We are lucky. How about the lack of procedure or the law? We are lucky that we have one. But for those countries that do not have one, that is a problem. This is the reason why there are some instances that the venue or jurisdiction is being questioned by a litigant in a case. They will argue that a witness is being coached while testifying via video conference, or not able to observe the decorum of the witness, or the witness was merely reading the answers to the questions, or reading something from the paper, or that's what. Moreover, they will say that the witness can lie because they are not afraid of being held in contempt of court or placed in jail, because they are saying we are not testifying in court anyway. Okay, or for those who do not have rules, okay, you have to lobby by writing concept notes or position papers to the proper authorities to make it happen. Okay, how about lack of knowledge to operate the computer or to do video conferencing? Okay, you can still resolve it by doing trainings or tutorials. To do those who do not know much about computers, we were branded just as Jurassic, illiterate, or antiquated. but this is just a temporary setback, because you may become an expert in just an hour or minutes or maybe more days. What matters is that you are not afraid to embrace new knowledge or skills. You cannot go wrong about it. The least of the problem is the lack of device or equipment. That's why I am in a quandary why this poll result becomes the second or the third reason.
The
Because
second.
that is no longer a challenge at this point in time, because all of us have a cell phone, even a small children. So, or tablet, the small child have a tablet, a cell phone. So that is no longer a problem. So thank you.
Thank you so much, Judge, for giving us all of these insights into all of the choices. We appreciate that very much. And also let us now hear from Judge Taswiwa for his reaction.
Thưa quý vị đại biểu, thì các cái biện pháp mà hạn chế đối với việc xét xử trực tuyến cũng như là lấy lời khai trực tuyến của nạn nhân và người làm chứng, thì tất cả các vấn đề về pháp lý, kết nối internet, kiến thức và đáp ứng được các cái thiết bị phù hợp, thì đây đều là những thách thức lớn mà qua các chia sẻ của các thẩm phán thì sau các nước thì đều gặp phải. Về phía Việt Nam thì hoạt động xét xử trực tuyến cũng là một cái hình thức mới, nên hiện tại thì trong hệ thống pháp luật tố tụng hình sự, đặc biệt là trong bộ luật tố tụng hình sự của Việt Nam thì chưa quy định về cái hình thức xét xử trực tuyến này. Nên đây là một cái hình thức rất mới mà Việt Nam cũng mới được thực hiện từ mùng 1 tháng 2 năm 2022, và hiện nay thì mới được thực hiện một số tỉnh có điều kiện. Thì ở Việt Nam thì đã cái hệ thống pháp lý, hành lang pháp lý thì mới được Quốc hội Việt Nam ban hành cái nghị quyết số 33 năm 2011, và sau đó được Tòa án Dân tối cao có một thông tư hướng dẫn để thực hiện cái phiên xét xử trực tuyến. Do vậy là cái hành lang pháp lý của nước chúng tôi thì bây giờ mới bắt đầu đặt nền móng cho cái việc xét xử trực tuyến và thay đổi cái hình thức xét xử truyền thống là xét xử trực tiếp bằng lời nói. Nên việc tổ chức cũng còn chưa được đầy đủ về cái hành lang pháp lý, nên nó có sự ảnh hưởng đến tính pháp lý của việc cung cấp chứng cứ, cũng như tính thống nhất trong toàn quốc giữa các tòa án các tỉnh với nhau để thực hiện việc đánh giá và các cái thủ tục cung cấp chứng cứ đối với những các cái trường hợp cung cấp chứng cứ ngoài phòng xét xử. Trên đây là cũng cái thách thức lớn nhất, là rào cản lớn nhất của Việt Nam để là cái hành lang sau đó thì trên cơ sở có cái hành lang pháp lý thì sẽ được thực hiện những các cái đầu tư về cơ sở vật chất để phục vụ cho việc xét xử trực tuyến, cũng như bố trí những các cái điểm xét xử, điểm cầu để người nạn nhân, người làm chứng họ lựa chọn cung cấp các cái chứng cứ, thủ tục cung cấp chứng cứ cho tòa án. Và đặc biệt là trong các cái dữ liệu điện tử khi xét xử trực tuyến thì việc thẩm tra chứng cứ, đánh giá chứng cứ cũng là một cái khó khăn. Thì trên đây là cũng một số khó khăn mà chúng tôi trực tiếp xét xử những vụ án mua bán người nói riêng và các vụ án khác nói chung qua hình thức trực tuyến thì có gặp khó khăn như vậy. Thì xin chia sẻ với các đại biểu. Xin trân trọng cảm ơn.
Thank you so much, Judge, and also thank you for emphasizing the need for enabling legal frameworks as well as a challenge. And I think that was also what Judge Sulid mentioned about laws and policies, that we need to revisit them and make sure that they are up to date with the advancement of technology. So thank you so much to all your responses to the poll questions. And of course, thank you to our online participants for engaging with us through the poll questions. We really appreciate your answers to the poll questions. So just a quick reminder, the link to the feedback survey will be again posted on the chat box. Please don't forget, for those who are non-English speakers, participants, one is available in your language to fill up the feedback form. All right, so now let us play a video of Thailand prosecutor Suganya Ratananakin, who would also share with us very briefly about Thailand's experience using technology in presenting evidence.
ในฐานะที่ดิฉันเป็นพนักงานอัยการที่มีประสบการณ์ในการดำเนินคดีค้ามนุษย์ในชั้นศาลพบว่าการดำเนินคดีค้ามนุษย์ในชั้นศาลหลายคดีที่ไม่สามารถที่จะดำเนินคดีต่อไปได้เพราะผู้เสียหายไม่ให้ความร่วมมือหรือไม่สามารถที่จะให้การเป็นพยานในชั้นศาลได้ด้วยตนเองดังนั้นจึงควรมียุทธวิธีที่จะทำให้ผู้เสียหายให้ความร่วมมือในการดำเนินกระบวนการยุติธรรมทางอาญาในปัจจุบันเทคนิคที่เน้นผู้เสียหายเป็นศูนย์กลางในการรับคำให้การจากระยะทางไกลโดยวิธีการทางอิเล็กทรอนิกส์โดยการจัดสถานที่ที่เหมาะสมให้เกิดความสะดวกกับผู้เสียหายและให้ผู้เสียหายรู้สึกว่ามีความปลอดภัยในขณะให้การเช่นในสถานทูตโดยผ่านระบบสกายหรือระบบซูมเพื่อเชื่อมโยงผู้เสียหายกับศาลแน่นอนว่าผู้พิพากษามีอิสระที่จะใช้ดุลพินิจในการชั่งน้ำหนักพยานหลักฐานหรือคำให้การที่ได้มานอกศาลแต่ถ้ามีกระบวนการที่จะสามารถสร้างความน่าเชื่อถือในการให้ได้มาซึ่งพยานหลักฐานได้เช่นการให้ผู้เสียหายสาบานตัวตามหลักศาสนาของตนและลงนามในคำสาบานว่าได้ให้การด้วยความสมัครใจที่เป็นความจริงและถูกต้องมีคดีหนึ่งที่ผู้เสียหายเคยให้การเพิ่มเติมไว้ในชั้นสอบสวนโดยบันทึกไว้เป็นคลิปวิดีโอและอัยการได้ยื่นบัญชีระบุพยานไว้แต่ในชั้นศาลผู้เสียหายลี้ภัยไปอยู่ประเทศที่3และไม่สามารถที่จะตามตัวผู้เสียหายมาเบิกความในชั้นศาลได้เป็นเหตุให้ศาลชั้นต้นยกฟ้องแต่ผู้พิพากษาในศาลสูงได้มีโอกาสดูคลิปวิดีโอดังกล่าวที่อัยการยื่นไว้ต่อศาลซึ่งวิธีพิจารณาคดีค้ามนุษย์ใช้ระบบไต่สวนคือศาลมีหน้าที่ในการค้นหาความจริงเป็นเหตุให้ศาลอุทธรณ์พิพากษาลงโทษจำเลยโดยใช้เหตุผลจากข้อเท็จจริงที่ผู้เสียหายเคยให้การไว้ในคลิปวิดีโอที่ในชั้นสอบสวนเพิ่มเติมดังกล่าวที่มีสภาพที่ผู้เสียหายถูกเอารัดเอาเปรียบจากกลุ่มผู้กระทำความผิดที่ศาลเชื่อว่าเป็นข้อเท็จจริงที่น่าเชื่อถือและว่าจะเป็นความจริง
Thank you very much, Eve. I'm happy to pass the floor to any of our distinguished panelists who would like to give their reflection or response to the message of or sharing of Prosecutor Suganya. Please be mindful of the time. We have only until 4:40 to entertain some questions. There are a lot in the chat box. If any of you, if you look at the Q&A box and there are questions that are specifically addressed to you, please, if you're okay with answering directly in the chat box in response to the question, you may do so. But we will give time also to address some of those answers here now. So we have until 4:45. Let's do that till 4:45 quickly to just answer, give your response to the video.
Can I take the floor, Fiscal Darlene?
Yes, please.
I just love how Ms. Suganya mentioned about one case where evidence was provided in the interrogation stage by recording it in a video clip. But later the victim fled to another country and could not be summoned to testify anymore. Court of first instance dismissed the case, but the Court of Appeals convicted the trafficker on account of the fact that the victim had previously testified in a video. So that video preserved the testimony of the victim. IJM and our partners strongly advocate for the same thing. IJM has been working with justice system partners to mainstream videotaped in-depth interviews in the prosecution of OSEC-related and trafficking cases as a child protective prosecution strategy by collaborating with the Department of Justice Interagency Council Against Trafficking with the Interagency Council Against Child Pornography, with the Supreme Court Office of the Court Administrator, family court judges, and some PhilJA lecturers. We conduct comprehensive VD trainings for law enforcement agents and for our partner prosecutors and DSWD social workers. Because when VDs are conducted and recorded properly, they are admissible as evidence and can be presented in lieu of live victim testimony during trial. And as it's intended to serve as evidence, it takes on the nature of a child forensic interview. It's an inquiry conducted by duly trained members of a multidisciplinary team or representatives of law enforcement or child protective services for the purpose of determining whether child abuse has been committed. Let me just finish by saying that, because I know we have limited time, VDs are a highly effective way to shield online sexual exploitation of children victims from the trauma caused by the rigors and complexities of multiple interviews and trial. It reduces the number of times a child has to tell his or her story and preserves the statements for future review by agencies or the court. It is therefore our fervent hope that more prosecutors and judges would see the value of videotaped in-depth interviews or VD as a victim-centric and child protective measure. Thank you.
Thank you so much, Attorney Kat, for that. Who would like to share as well?
Can I react? Okay,
Yes,
thank
Judge
you.
Reed.
Okay. Based on the statement of Ms. Sugaya, it appears that the video clips of the victim in human trafficking case was taken before the case was filed in court. And the judge, the Superior Court judge, considered the said video as sufficient evidence to convict the accused. Although the procedure is commendable, there are several questions that lingers in my mind. Number one, it is an inquiry for purposes of gathering evidence to be used in the filing of the case in court, or it is a court proceedings. Number two, who was present during the taking of the victim's testimony? Number three, who presides during the proceedings? Number four, is this the only evidence considered by the High Court in convicting the accused? Okay. Although this is similar to our videotape or audio tape disclosure interview, but as I said before, okay, we only admit or this evidence is only admissible if the child is not available to testify in court. Number two, among others, the requirement, okay, that it is conducted by a duly trained multidisciplinary team composed of doctors, police, social workers, psychologists, among others. Number three, that the recording, that record the video or audio is capable of, or the equipment is capable of recording. Number four, okay, the one who operates the recording is capable to record it, okay, and that this recording is authentic, okay, is authentic among other requirements. Then the court will admit it as admissible in evidence. But as I said, okay, since the victim will not testify directly in court, okay, this is only a corroborative evidence. This videotape of the victim should be supported by other circumstantial evidence tending to prove the culpability of the accused charged in the crime. This alone is not sufficient evidence, I tell you, in our court. This alone. Because what? Because of what? Because the child is not, because the accused who is charged in court is not there to witness the ongoing inquiry. The accused counsel is not also there to witness the inquiry. That is a violation of the constitutional rights of the accused to fair trial. Okay, thank you.
Thank you so much, Judge. I think that is very clear. Thank you for sharing with us the needed criteria to accept this kind of evidence. So let's also hear from Judge Suiwa, and then from Judge Picton.
Thưa các quý vị đại biểu, nào thẩm phán xét xử các vụ án mua bán người thì bản thân tôi cũng gặp những khó khăn tương tự trong việc đánh giá chứng cứ để kết tội đối với bị cáo tại phiên tòa, đặc biệt là các chứng cứ cung cấp ngoài phòng xét xử và các cái chứng cứ điện tử được thu thập trong quá trình giải quyết vụ án thì chủ yếu gặp phải khó khăn trong việc thu thập chứng cứ đối với nạn nhân và người làm chứng, vì họ là người phải chịu ảnh hưởng về mặt tâm lý và tinh thần, nên việc diễn biến lời khai của họ thì không được thống nhất, và các cái việc phạm tội của cái tội phạm mua bán người thường nó có yếu tố ở ngoài lãnh thổ quốc gia. Khi bắt được cái người phạm tội thì nó trải qua một thời gian rất dài so với cái thời điểm mà nạn nhân, người làm chứng khai. Còn cái việc mà lấy lời khai của bị hại và người làm chứng thì chủ yếu là cung cấp, người bị hại và người làm chứng là họ sẽ cung cấp trực tiếp tại cơ quan tiến hành tố tụng sau khi mà họ bị đem bán, và có thể là họ trốn thoát về trình báo các cơ quan, ban đầu là cơ quan điều tra, công an. Thì những cơ quan này họ sẽ tiến hành lấy lời khai bằng việc ghi biên bản và ghi âm và ghi hình có tiếng. Thì khi hoạt động tố tụng thì các cái hoạt động văn bản này sẽ được sử dụng chứng cứ tại phiên tòa. Các hình thức cung cấp lời khai của người làm chứng thì tại Việt Nam thì cái hình thức tự ghi hình ghi âm để cung cấp cho tòa án thì nó còn hạn chế, đặc biệt là lời khai bên ngoài phòng xét xử. Thì đối với những các cái tài liệu mà họ cung cấp thì có thể phải qua giám định để kiểm tra tính xác thực. Đối với việc sử dụng chứng cứ và thu thập chứng cứ tại việc mà bị hại ghi âm ghi hình để gửi đến tòa án thay cho họ trực tiếp đến phòng xét xử thì hội đồng xét xử sẽ thẩm tra đánh giá đầy đủ trên cơ sở phù hợp với các cái chứng cứ khác của nạn nhân, của người làm chứng và lời khai của những người tham gia tố tụng khác. Khi đủ tin cậy, cơ sở pháp lý thì có căn cứ để hội đồng xét xử kết tội đối với bị cáo. Thì trên đây là một số chia sẻ của tôi với tư cách là thẩm phán đã xét xử những vụ án mua bán người, thì chia sẻ cùng với tất cả quý vị đại biểu. Xin trân trọng cảm ơn.
Thank you very much, Judge Suiwa. Also very relevant comments to the changing times that we now have. And now may we also hear from Judge Picton.
Thank you. There's two stages to it, which are quite distinct and partly due to our adversarial process of trial, which is different perhaps from some. The account given by the child or the victim of trafficking to the police that is video recorded, that is evidence. And on its own, it would be sufficient to convict if it reached the standard. There is no legal requirement for there to be corroboration of an account given in that way. And that video recorded account is admissible in evidence at court. Simply play it. That is the evidence in chief. As to the potential to challenge that evidence by way of cross-examination, if the witness is available and capable of being cross-examined, then our system is that the witness will be challenged, the accused will have a chance to put an alternative case. The advantage of the pre-trial cross-examination is it accelerates that process and potentially a very long way, so that the witness is challenged much closer to the time, and the witness can then go on and move on in their life without the oppression of waiting to give evidence for months, sometimes years, hanging over them. In the human trafficking case I mentioned that I conducted earlier this year, the police arrested the accused in 2017. They conducted the evidence gathering interviews with the victims in 2018 and 2019. Because of the complexity of the case and the COVID interruptions, I didn't start the trial till January 2022, but the evidence that the jury heard were the accounts given by the victims in 2018 and 2019. They were then cross-examined whilst in a different country in 2022. So that's the way the system worked, because there wasn't pre-trial cross-examination, because it wasn't available back in 2019. Now there would be pre-trial cross-examination as well for those witnesses, and the trial could then be years later if necessary, but you've captured the evidence at the time. I haven't addressed all the points, but maybe that's all I've got time to deal with at the moment. I can say more perhaps later.
Thank you so much, Judge. I think that's now more clear. And I think having listened to all of you, all of your sharing, there are really we would really appreciate to know that the fact that we are now very open to having pre-recorded evidence or advance recording of the testimony of victims, provided that it does not violate the right of the defendant to challenge those evidence. Thank you so much again for all your sharing. I think we have enough time to read at least one question for each of you. We won't be able to answer all of the questions. We will try to answer those questions offline later on. So may I now give the floor to my co-moderator, Kem Siguan, to facilitate the question and answer.
Thank you so much, Darlene, and our dear panelists. Such a rich discussion, and I think 2 hours is not enough for this kind of an interesting discussion for all of you, for really good panelists on this topic. I'll ask first Judge Christina, I think, with the first question from the Philippines. Is the video in-depth interview admissible in court as evidence if the case is rape or other forms of sexual abuse not related to online sexual exploitation and abuse of children? Judge, please.
Not related to?
To online sexual abuse and exploitation of children.
As long as there was a child abuse case, it is applicable. And as I said, admissibility of this kind of evidence there are several requirements.
Yes, Judge.
Okay. As I mentioned, the inquiry or the investigation inquiry is to be conducted by a multidisciplinary team composed of the police, doctors, social worker, or psychologists. Number 2, that the child is not available to present the testimony in court, meaning to say he or she is dead, suffering from mental illness or trauma, okay, loss of memory. Okay, number 2. Number 3 requirements, that the recording or the device recording the audio or the video is capable of recording it. Okay. Number 4 requirements, that the person who operates the recording device is competent and capable of, because of the qualification, to record it. Okay. Number 6, it also number 6, among others, there are several requirements. Okay, and that the prosecutor or the one presenting the said evidence should present to the court that this is authentic, it is not fabricated or spliced. Okay, that are the requirements. Therefore, the court will consider that this evidence is admissible. But as I said before, this is not enough to sustain conviction of the offender. This should be collaborated by other circumstantial or supporting evidence that tend to prove the culpability of the accused. Okay, thank you.
Thank you so much, Judge. I think, yes, that is very clear. Thank you for reiterating the requirements. I think we have a lot of law enforcement officers in the room, and I think they heard you. The next question is for Judge Picton. Honorable Judge Picton, I know that you've been advocating for alternative modes of presenting victim testimonies, but there's a question. The question says, are there any loopholes in pre-recording testimonies? I think it could also mean that what are the disadvantages in pre-recording testimonies? Over to you, Judge Picton, please.
It's one of the great unanswered questions as to what impact, if any, on the verdict the receipt of evidence by way of a pre-recorded account played to the fact finder and cross-examination over a remote link, whether pre-trial or during the trial, what impact that actually has on the conclusions of the fact finder, whether they are more likely or less likely to believe the witness. And there are people who take the view that you get a better feel of the witness's reliability and credibility if you see them, you know, in the same room. You're seeing them in the flesh, as it were. I don't buy that myself. I think we are better than that as fact finders, and that we place maybe too much reliance on, if it's not a reference that misses a number of you, the Pinocchio test of witness assessment, of evidence assessment, if that translates. That's testing the interpreters. But, you know, it's a subtle process assessing a witness's evidence. I'm not sure there is that degree of loss of impact if it's on a video link, but it's an unanswered. It's very difficult to research. How do you research whether there would have been a different verdict if the witness had been physically in court and the whole thing had been done in a more traditional way? I don't know, but you have a balancing process of ensuring that the case gets tried at all, because you just can't keep traumatizing victims again and again by making them repeat experiences that for them have been devastating, and the process of repetition is secondary victimization to them, to those who have to listen to it. You just can't keep doing it. So I think we have to move on. We have to adopt more modern processes that are more humane. Pitfalls, yes, it requires the fact finder to concentrate hard on the evidence, to understand that what they're seeing on screen is the evidence, but it doesn't need to be corroborated. The account, pre-recorded account given by a witness, challenge where that can be done effectively, that is enough. We don't require corroboration. We've moved away from that. I hope that's
Thank you
helpful.
so much. Yep. Thank you, Judge Picton. And I think one lesson learned from you also is just reaffirming that different jurisdictions have different rules and procedures, and there are different levels of maturity in terms of accepting the different modes of presentation and accepting evidence in the different cases. This question is specifically for Attorney Kath from one of our participants, Leisha. Attorney Kathleen, do you think the only way the French were able to get a conviction in the case of Jennifer, I think, was because she was able to give her evidence, and because that evidence was given remotely? And if I may add before you answer, Attorney Kath, what were the lessons learned for you in terms of international legal cooperation in trafficking cases and mutual legal assistance in that regard? Over to you, Attorney Kath, please.
In my opinion, even if Jennifer did not testify in that case, the French abuser would still have been convicted. They needed her there, particularly more because they were also looking after the award of restitution for Jennifer. In fact, when Jennifer testified, the accused was no longer in court. That's why the accused was able to confront Jennifer. And with regard to stronger international collaboration, with regard to Jennifer's case, I remember that the Attorney General highlighted the exceptional character of international cooperation system implemented during the trial between the French and Philippine judicial authorities. He said that it is only through the remarkable engagement of various actors, including the lawyer for the French NGO, France Victim 37, the Philippine government and judicial authorities, the service of the French embassy in Manila, and the chain of the French prosecutors, that the young victim survivor was able to be taken care of and heard via video conference. online sexual exploitation of children, a form of cyber sex trafficking, is one of the fastest growing major crimes in the world, with a hotspot in the Philippines as a source country. So the conviction of Jennifer's trafficker is a perfect example of how global coordination can bring victims of exploitation to safety and strength, and their perpetrators to justice. This form of modern-day slavery transcends national boundaries. Therefore, combating this crime type, this evil, this menace, requires strong cross-border cooperation and strong collaboration of international partners. Some resort to the use of a mutual legal assistance treaty, but with other countries where the Philippines has no MLAT, the Department of Justice, Office of the Chief State Counsel, and the Office of the Cybercrime are still open to receive requests for legal assistance, sometimes even through informal channels. Formal requests can be phrased in such a way quite similar to a mutual legal assistance treaty request. So they accept requests for assistance even without an MLAT. I hope I answered the question. Thank you.
Excellently, Attorney Kathleen. And the final question, going to Vietnam, to Judge Ta Si Wa. I know that there are a lot of questions from our participants and really good ones, but we only have a limited time. Judge Ta Si Wa, for Vietnam, in your view, what are your hopes for your jurisdiction? What are your hopes of improvement in terms of accepting alternative modes of presentation of evidence in trafficking cases? Where do you see your jurisdiction? Where do you want your jurisdiction to improve in this regard?
Thưa quý vị đại biểu, thì hiện nay trong hệ thống tố tụng Việt Nam thì mới thực hiện cái việc lấy lời khai bằng việc ghi âm ghi hình bởi các cơ quan tiến hành tố tụng là cơ quan điều tra, viện kiểm sát. Còn về phía tiến hành tố tụng tại phiên tòa thì Việt Nam đã bắt đầu thực hiện phiên tòa trực tuyến và bố trí các cái điểm cầu lựa chọn, đặc biệt là đối với bị hại và người làm chứng thì họ có quyền được lựa chọn một cái điểm cầu mà họ tự bố trí. Sau đó thì họ sẽ có cái biên bản trình đến tòa án và được tòa án đồng ý. Thì đây là cái điều kiện để hướng tới tạo điều kiện cho nạn nhân và người làm chứng có điều kiện tốt nhất và cái điều kiện tâm lý tốt nhất, cũng như đảm bảo được các cái quyền con người ở mức độ cao nhất. Thì hướng tới trong thời gian tới đây thì Việt Nam sẽ tổ chức nhiều các cái phiên tòa trực tuyến. Thì hiện tại mới đang lựa chọn một số vụ án nó có tính chất đơn giản để tổ chức sau, và ở một số tỉnh có điều kiện về mặt viễn thông cũng như cơ sở vật chất. Thì trong thời gian tới thì chắc chắn Việt Nam sẽ xây dựng một hành lang pháp lý đầy đủ và được quy định chính thức trong hệ thống tố tụng Việt Nam, và sẽ được thực hiện thống nhất trên toàn quốc. Và đây cũng sẽ là một hình thức thay thế những các cái hình thức tố tụng trực tiếp hiện nay đang thực hiện. Thì cái xu hướng thì sẽ dần dần hoàn thiện và sẽ được phát triển về sử dụng khai thác các cái công nghệ thông tin để phục vụ cho việc xét xử, điều tra, truy tố, cũng như việc tạo điều kiện cho nạn nhân, người làm chứng thực hiện được cái quyền của mình tốt nhất, đảm bảo được cái quyền lợi của họ ở mức tối đa nhất theo đúng quy định của pháp luật. Xin hết.
Thank you so much, Honorable Judge, and thank you also to all the other panelists and our participants for your questions. Back to you, Darlene.
Thank you so much, Ken, and of course to our panelists. Thank you too to the online participants for your thought-provoking questions. We will again try to answer your questions offline via our portal. Again, may I invite our esteemed experts the opportunity to share any final thoughts for our audience. we can start with Judge Picton, please.
Well, I'd like to say thank you for the opportunity of participating. I have to say I found it really informative, really educational, absolutely fascinating to hear the experiences of others. And it's good, all the common points that link us. It's incredibly encouraging. And I think from the perspective of those who have suffered, these are important steps forward in the future.
Thank you very much, Judge. Attorney Kathleen.
First of all, I would like to thank ASEAN-ACT for the opportunity. Thank you for having IJM in this webinar. I also appreciate Judge Picton. Thank you for the call to action that we should be moving towards more modern and humane processes. We have our Philippine Constitution that kind of restricts the way we present child-friendly evidence, child protective measures. But we really appreciate that you imparted to us that kind of wisdom, Judge Picton. And let me just close by saying that one of my greatest mentors in the practice of law, Attorney Lawrence Aritao, who was also a panelist in a previous webinar of ASEAN-ACT, he used to tell me that there is no greater, higher use of the law than to protect the vulnerable and restore the broken. I firmly believe that. The convictions we secure for survivors of trafficking and online sexual exploitation of children show that when prosecutors, law enforcement, and other justice system actors between countries work together, justice is unstoppable. Thank you very much.
Thank you very much, Attorney Kat. And now may we hear from Judge Taswi Wah.
Xin cảm ơn ban tổ chức đã tổ chức cái buổi hội thảo trực tuyến để các thẩm phán, các quốc gia, các hệ thống pháp luật khác nhau để trao đổi, học hỏi kinh nghiệm và tiếp thu những các cái mới, các cái tiến bộ của hệ thống pháp luật các nước để góp cho chúng tôi được có những các cái hoàn thiện về mặt pháp lý tốt hơn và các cái kinh nghiệm trong việc đấu tranh phòng chống tội phạm mua bán người cũng như các cái tội phạm khác được tốt. Và xin cảm ơn sự chia sẻ của các thẩm phán và các vị đại biểu để chúng tôi được tiếp tục học hỏi, kết nối giữa các nền pháp luật của các quốc gia và các hệ thống pháp luật trên thế giới được giao thoa và có sự học hỏi, tiếp thu những các cái tinh hoa của pháp luật các nước. Xin cảm ơn.
Thank you very much, Judge Taswi Wah. Now we will call on Judge Chris Tulit.
Okay. What we learned today is a living testament that children are vulnerable to all kinds of abuses. We know the limits and restriction of children who would enter the judicial system, whom they never wanted to in the first place. We empathize with their plight, regardless of whether they are victims, offenders, or mere witnesses. We know how difficult it is to stand inside the courtroom. Therefore, they must be accorded more rights, respect, understanding, empathy, support, and protection, not only during the taking of their testimony, but also afterward, to ensure their speedy recovery and rehabilitation. We should guarantee their rights and should protect them for further harm. With this in mind, we hope and pray that every nation in the world shall adopt its own court procedure in handling children with open mind and heart to facilitate the attainment of truth for the swift administration of justice. Let us all join together and work towards it. After all, it takes the whole village to raise a child. Hence, everyone's Hence, everyone must do their share. There is no greater reward than to see our children free from the hassle and bustle of court proceedings and any form of abuse. Thank you, ASEAN, Australia Counter-Trafficking for the invitation, and good day to all.
Thank you so much, everyone. Excellent sharing and advice to our audience. I myself have learned a lot from all of you, and I will not forget, especially what Judge Victon has said, there is no measure that is a one size fit all, especially because we have different levels of maturity, different levels of readiness, different infrastructure, different laws. So again, thank you so much as well to all of our participants. May I now invite our team leader, Dr. Lucia Pauter-Pauli, to give her closing remarks.
Thank you so much, Darlene. Distinguished panelists, ladies and gentlemen. I have the great pleasure of closing this incredibly informative webinar today on evidence presentation, specifically whether alternative modes of presenting victim testimony can increase chances of conviction in trafficking cases. Our topic today is fitting, given that throughout this month, we will be commemorating World Day Against Trafficking in Persons, which has a focus on technology as both an enabler of trafficking, but also a powerful tool to counter trafficking and to protect the vulnerable. And of course, well beyond the month of July, this topic will continue to be central to counter-trafficking initiatives of all ASEAN member states as they continue to progress towards full and consistent implementation of the ASEAN Convention Against Trafficking in Persons, especially women and children. First, I would like to express my sincere thanks to Australia's Ambassador to ASEAN, Will Nankervis, for opening our webinar today, and to the ASEAN mission more broadly for your strong support to our entire webinar series. This webinar series is facilitated through Australia's very long-running support to ASEAN to improve justice responses to human trafficking with a strong focus on the rights of victims. Secondly, I wish to acknowledge and thank our very prestigious panel. We know that it's not easy for judges and prosecutors to take time away from the court and from your very busy professions. And so we're so grateful for your generous sharing about alternative modes of evidence presentation. His Honour Judge Martin Picton, thank you so much for sharing the cutting-edge principles and techniques being used in the UK and Wales to support vulnerable witnesses to give their best evidence in court in a manner that is safe and avoids further harm and trauma to victims. We particularly noted that it is not only victim witness testimony that can be provided virtually, but also cross-examination that can be recorded in advance. This is such an innovative practice that I hope judicial actors in this region may be able to learn from. Thank you also for outlining the legislative basis in the UK that enables a range of special measures for vulnerable victim witnesses, including people with disabilities, children, victim witnesses who may be fearful or traumatised because of the court experience. The special measures framework and accompanying procedures and practices really demonstrates that everyone can have fair and equitable access to justice with some simple adjustments supported by the right technology. And thank you also for reminding us of the importance of defendants, who are also, of course, entitled to special measures to enable them to participate fairly and equitably in the trial. This is particularly relevant for us as counter-trafficking actors, as we know that some victims of trafficking end up in court as suspected perpetrators if the non-punishment principle is not effectively applied. To our presiding judge, Christina Havarela Sulit, thank you so much for outlining the various ways in which the Philippines has taken strong measures to protect children, be they victims, witnesses, or suspected offenders. As the ASEAN Convention states, children should be treated differently and specially in recognition of their vulnerability and of their heightened potential to suffer trauma or other forms of harm as a result of exposure to criminal justice processes. Some of the measures you outlined, including video conferencing, pre-trial testimony, allow children to stay safe and supported and to testify from a range of locations, even overseas. And I thank you also for pointing out some of the challenges in giving alternative modes of evidence, including the lack of internet connection, which is still a very real challenge in parts of our region, Southeast Asia, and how to verify the evidence to ensure that it's admissible in court. Whilst there are challenges, I have full confidence that with the advancements in technology and the development in the region, we will move further and further towards the adoption of these kinds of technologies. To Intermediate Judge Ta Se-Wah, you added a very important point on the importance of using qualified child psychologists and support workers to ensure that children are handled sensitively in the courtroom. It was great to hear that courts in Vietnam regularly close trials to the public, and also that you can organise alternative rooms for vulnerable victim witnesses. You also shared that Vietnam has recently passed some groundbreaking legislation on the use of video and remote testimony. And it struck me that the ability to use video testimony does not only minimise harm and protects victims, but it also allows for justice seekers from more remote and rural areas of the country to have greater access to the courts. And you mentioned that this measure has already been used in some provinces of Vietnam, which is fantastic. You also outlined some of the challenges in collecting and using digital evidence, which has been identified as a common challenge right across the ASEAN region, and a challenge that ASEAN-ACT will definitely be focusing on going forward. And to Attorney Kathleen Joy Pisholabai, thank you so much for sharing your very recent experience on this landmark case involving a minor who was sexually exploited by a French national and able to give evidence from the French embassy in Metro Manila. There are so many things to love about this case. First, that it was a mutual legal assistance request and showed formal cooperation in a child trafficking case, which we still know is relatively rare. The fact that the child victim was able to have a support person there, the way the French embassy was able to provide a safe and supportive space for the victim to testify with a lawyer present, the sense of empowerment that was felt by the child victim in being able to provide her story and contribute to the justice process. This case is simply inspiring and really shows what's possible if we cooperate across jurisdictions and think first and foremost of what is actually best for the victim. So in closing this webinar today, I think we need to come back to our initial question. Can alternative modes of evidence presentation actually increase chances of conviction? I think it's very clear from the perspectives presented today that when victim witnesses, in fact, all witnesses, as Judge Picton reminded us, are supported and feel safe, they will give their best evidence, which maximises their chance of a conviction. I think it's also very clear that technologies such as video conferencing open up possibilities for those who may have not previously been able to access or pursue justice due to distance, due to accessibility barriers, or for fear of having to present and be re-traumatized in court. From both the perspective of the judiciary and from the perspective of victim witnesses and their support persons, I think it's very clear that alternative modes of evidence can result in better justice outcomes, especially when we think about justice in the broad from the perspective of the victim as well as a criminal conviction. Finally, I'd like to thank all of you for joining online, for your enthusiastic participation in our polls, and thank you for your excellent questions raised in the chat. I've certainly found today's webinar very thought-provoking and, in fact, hopeful because technology opens up so many more possibilities for protecting victims and witnesses and for pursuing justice across borders when dealing with very complex and traumatizing crimes like trafficking in persons. We look forward to seeing you again at our next webinar in early October. And once again, thank you very much.
Thank you very much. Thank you very much, Dr. Lucia, for closing the webinar on such a positive note. We did have such a robust discussion, and we hope to have gained a lot. Our audience have gained a lot from this webinar, especially on what can be done to provide victims more protection through technology as they go through the criminal justice process without affecting or jeopardizing the integrity of that process. So on behalf of ASEAN-ACT, please accept our warmest appreciation. It has been an honor and pleasure to have you, His Honor, Judge Martin Picton, Presiding Judge Cristina Javalera Sulit, Intermediate Judge Ta Se-Wah, and Attorney Kathleen Joy Pisholabai, and of course, Prosecutor Suganya Ratananakin. Thank you. It has been a very amazing day to end or start for Judge Picton and others who is where it is still morning. So much energy in the room. Thank you too to our ASEAN-ACT team leader, Dr. Lucia Pauter-Pauli, my co-moderator, Kem Siguan, and all the untiring support of the ASEAN-ACT team behind the scenes who made this webinar a success. To our online audience, we'd love to hear your thoughts. So kind reminder, please fill up the just one page feedback survey. The link is shared in the chat box. Your comments matter to us. And your certificate of attendance will be sent to your email address that you will provide in the survey. So reposting the link on to this webinar as a the feedback form in the chat box now. So this Zoom webinar recording will be uploaded to our portal where you can access it, including the presentation of Judge Martin Picton, the video of Prosecutor Suganya, and all other materials that we can share in relation to this webinar. So see you next in our webinar, which will be on October 7 about support models for victims of trafficking. So continue to stay safe and well. Goodbye.
Bye, Darlene. Bye, everyone. Thank you.
Thank you and goodbye. Cảm ơn anh Ước rất nhiều ạ.
Cảm ơn ban tổ chức.